Hey, y'all, and welcome to tonight's live stream. Well, the Karen Reed jury does not agree. That much we know. So far, they have deliberated for 21 hours over a 4-day period. And so far, they look about like the rest of society, which is they don't agree. And if they are like the rest of society, then they don't agree strongly. It may be heavily weighted on one side, but they don't agree. So today we are going to cover what's happening with the jury. We're going to cover what's a hung jury? Are we headed for a hung jury? What steps can the judge take to avoid a hung jury? We're going to be asking the questions like, why is Karen's team pushing for a dynamite charge? Why is that controversial? And we're going to be talking most specifically about what comes next, about what is going to be coming next for Karen Reed and for the case that we've been following for weeks now. So I want to say a special shout out and welcome to the first 5 who were in the chat: Miss Construe, Rita Young, Deborah Smouse, Jody Arrington, and Nona Malou, and a special shout out to Connie, who is real close. And so everybody, if you would hit the like button, I would really appreciate it. It'll help the video get out to more people, and subscribe because we would love to have you back for more. So let's talk first. What is a hung jury, and are we about to see one? A hung jury is just a jury that can't reach a verdict, a jury that hasn't agreed yet on what the verdict is. In a civil case, it might be they can't agree on whether or not the plaintiff is owed damages. But in a criminal case like this one, some jurors believe guilty and some believe not guilty. It could be on all the charges. It could be on one charge. We don't really know in this particular case where the hangup is. We just know that the jury is not yet able to reach a verdict, and that they've been trying and that they don't agree. That's about what we know. And we're going to talk about we're going to unpack that and explain what happens next. What are the next steps for this? So, and what's interesting is it's unfolding pretty much just exactly like we laid it out last night, like we thought would happen. So yesterday, as the jury was leaving for the day, I gave y'all a clip, which I'm going to show you again. And in this clip, it's just a couple of seconds. The judge says something that I said, I think this means they don't agree. Here,
let's happen to see, hear, or read anything about this case, please disregard it and let us know. Clear your heads. We'll see you tomorrow.
All right. Okay, so what we learned from that little clip, the judge saying, clear your heads. I said, gosh, that to me sounds like this judge thinks that they're having a hard time, that they're having difficulty reaching a verdict, that they are really struggling together to come up with a verdict. And she's saying, clear your heads, let's start over again. We don't agree, but maybe we can all come back and agree tomorrow. So that was what she was pushing for. And I said, I think that comment right there suggests that we've got disagreement. And in fact, I thought that back on the first day when the jury came out, remember I said they drop little clues every time they come back. And on the first day in the morning, something they said was, we'd like to leave before 4 p.m. today. I said, there are a lot of things that could mean, but one option would be that they don't think they're going to agree. They certainly don't think they're going to agree by 4 o'clock today. They think it's going to take longer. Could be they're just reviewing evidence, but now we start to have more evidence. And today we learned for absolute sure. Here's what happened. Let me add this back to the stage.
Counsel, you're aware of our note from the jury. Dear Judge Cannoni, I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict. Signed by the foreperson.
So what does it mean? Does it mean that we're headed for a hung jury? The answer is very possibly. So the judge immediately moved into the hierarchy we talked about tonight. And I'm going to sort of set it out in order of what the steps will be that she'll cover next. She took one of the steps she could take today. That is, she decided whether or not the jury had tried hard enough, whether there had been due and thorough deliberation. Here's what she did to figure that out.
I want to hear from counsel, your view on whether there has been due and thorough deliberation. So let's start with the Commonwealth.
Okay, so we're going to hear what each side said on that in just a minute. But for right now, let's start with just this, which is she's looking for whether there had been due and thorough deliberation. So let's go back to that document we looked at yesterday. And I want to take us through, I decided maybe the best way to sort of do this is to do it in order. The document, like a lot of things that lawyers write, is not exactly in the most logical order. It's sort of in a crazy haphazard order, but I'm going to piece through it like, what's the first step she takes? And it's down here, number 1. This is from the this is from mass.gov, their .gov site. It's jury instructions related to when there is disagreement and the jury cannot reach a verdict. What do you do? What do you do if you're a judge? And it's to encourage the jury to go ahead and keep trying and to reach a verdict. So, number 1, to avoid subsequent problems with number 34, section 34, it suggested that the judge state clearly for the record whenever the judge determines that a potential impasse has not occurred, quote, after due and thorough deliberation. So you heard Judge Canoni say those very words in that clip I just played for you. She looked to see, have they finished? Have they done due and thorough deliberation? And if they haven't, she doesn't have to start with any of the rest of that. Sort of a threshold question. If they didn't carefully deliberate, if it's not due, it's not thorough, then she can just send them back for more and she doesn't have to go through the steps here. And she wants to avoid that if possible because she only gets one go round through these steps. And so this is an off ramp. First, was there due and thorough deliberation? And she said no. So let's go to number 2. What happens next? Let's say they keep trying and they come back and they still haven't reached an agreement. Well, there's a preliminary step that she can do. All of this is leading up to the big charge that she's going to give the jury. It's called the dynamite charge, the Allen charge. In Massachusetts, they call it the Tui Rodriguez charge. It's all the same thing. And the idea behind this charge is let's put a stick of dynamite under the jury. Let's see if we can break up this log jam and get them to come to an agreement, even though currently they don't agree. So the next step for her is this pre-Tui Rodriguez charge. And it says when the jury prematurely suggests it may be at an impasse, but the judge thinks, no, you're not yet deadlocked. You're not quite there yet. Then the appeals court suggests that they use what I'm about to show you. I'm going to have just a little clip of it because we went over this last night. So I want to keep it as little as possible to kind of talk our way through it. So, and here it is. It's from the American Bar Association, which is a national group of lawyers. And it says, it's pretty generic. It just says, hey, it's your duty as jurors to consult with each other. You have to certainly keep your own judgment and conscience, but don't be afraid to change your opinion and listen to everybody else, but don't surrender your honest conviction, which is all sort of confusing for a juror. But that's step number 2. And then there's a possible off-ramp again. She could still say, well, yeah, now that I've given you that, I don't really think there's been due and thorough deliberation since I told you that. But now we are, number 3, we hit the significant charge, the big charge. And this is what it says in the notes. The little print is the notes. The big print is the actual charge that would be read to the jury. It says it's appropriate for the judge to give such a charge when the jury is deadlocked, but because it has a certain sting to it, it should not be given prematurely. Don't give it early. And digression from the recommended language is discouraged. And in fact, it's one way cases get reversed. So here it is. I'm going to just give you a couple of sentences from it. The significant charge that she would give the jury if she tries all the other steps, and she's tried step 1, she just sent them back, said it's not been due or thorough, but she would try this next. And here it is. I'll just give you a few sentences from it, not the whole thing. It's going to say the verdict has to be the result of your own convictions. It can't be just you agree to what other people, even though you think they're wrong. Still, you have to decide with candor and with a proper regard and respect for each other's opinions. You should consider that it is desirable that the case be decided. You should consider that you have been selected in the same manner and from the same sources any future jury would be. There's no reason to suppose that the case will ever be submitted to 6, here 12 persons who are more intelligent, impartial, or more competent to decide it than you are, or that more or clearer evidence will be produced on one side or the other. So in other words, you keep what you think is right, but hey, realize that this group is as good as it's going to get. There's no other group that's going to come in that's going to be better. There's no evidence out there that's going to be presented that hasn't yet been presented. You've got it all. So you decide it. You right here and now, you decide it. And it says, give proper respect to each other's opinions. Jurors who are for acquittal, so those are people who think Karen should be not guilty, should consider whether a doubt in their own minds is a reasonable one. If it makes no impression on the minds of other jurors who are equally honest, equally intelligent, and who have heard the same evidence with the same attention, with an equal desire to arrive at the truth, and who have taken the same oath as jurors. So it's saying, look, if you think, well, I have a reasonable doubt, but you look around you and nobody else has that same reasonable doubt, and they seem pretty honest, pretty intelligent, pretty upright, then maybe you ought to look at whether you need to agree with them. Maybe you need to reconsider your opinion. The other way it goes is jurors who are for conviction. Those are the ones who are saying Karen Read should be found guilty. Seriously to ask themselves whether they may not reasonably doubt the correctness of their judgment if it's not shared by other members of the jury. They should ask themselves whether they should distrust the weight or adequacy of the evidence if it's failed to convince the minds of their fellow jurors. So the people on the side of the Commonwealth would say, well, gosh, I felt really sure that she was guilty, but I look around me and the other members don't seem to have that same conviction. Maybe there is a reasonable doubt that I haven't thought about. And so what the court is saying to the jury is, pay attention to what the other people have. Now, there is a natural effect of what happens here. And that natural effect is there is usually one side that has fewer people, one side that has more people. So it puts pressure, additional pressure, and we're going to talk in just a minute about why this is controversial. It puts additional pressure on the jurors who are in the minority, who don't agree with most people, because now they have to, it sort of puts pressure, if no one else around you is thinking this. So it puts some special pressure on them to re-examine and to maybe cave in. And that is what's made it controversial, but we'll talk about that some more in just a minute. So those are the steps. And the judge has been through the very initial part. She said that wasn't due and thorough. And let's take a look at what happens if she gives that dynamite charge. She has one more off ramp, but that's it. If a jury, after due and thorough deliberation, returns to the court without having agreed on a verdict, the state may state anew the evidence the court may state anew the evidence or any part thereof, explain to them anew the law applicable to the case, and send them out for further deliberation. So what would happen then? What that means is if the jury comes back and the court decides, this time this is due and thorough deliberation. The defense was right last time, or at least by now, this is due and thorough. We've had plenty of time. Then what the court does is this charge that I just showed you, and she can state anew the evidence or any part thereof and can give them the charge again. So state anew the evidence, explain to them anew the law applicable to the case. Now, that would be sort of a waste, wouldn't it? Because it's all written out. She literally read it, but she could do that again. She could read all the way through those charges again. It says state anew the evidence. It's not clear what that would mean or what she would say without emphasizing some parts more than others. But she has some leeway in there to do that. If she does that, if they return a second time without having agreed on a verdict, they shall not be sent out again without their own consent, unless they ask from the court some further explanation of the law. Okay, so there's another small off-ramp there. So if they come back again and they say, we really can't agree, but what we're hung up on is that the charge you gave us about involuntary manslaughter. We just really can't agree on that. We're having a hard time with that one charge. Then she could go back to the drawing board. She could talk to the lawyers. They could maybe agree on a different charge, or she could read it again. She could do something to try to focus them in on what that is. But other than them asking for that, two strikes and she's out. If they come back a second time, that's it. So the judge is trying to take this very, very slowly so that she goes through the process. And I'll read this other thing. Regardless of which instruction is utilized, after the jury has twice engaged in due and thorough deliberation, the judge may not send them out again without their consent. So, and that suggests that the judge may have to make a choice between the American Bar Association, which is much more minor, and the dynamite charge, the Tui Rodriguez charge, the more serious charge, or maybe do them both together. And so this is all suggesting she's going about this very deliberately. She very much wants this to be a decision that they make, but she wants them to get this done. She doesn't want them to just let it go. She doesn't want to try it again. Nobody does. Nobody in that courtroom. So then I want to talk about what happened. Remember, I said that the court asked the parties, okay, what do you want to do? The jury has come back and they say they can't decide. She said, is this due and thorough? Is it time for me to get moving and to give this charge and so forth? And here's what happened next.
My answer would be no, Your Honor. This simply hasn't been sufficient time yet.
And what does the defense say?
We believe that there has been sufficient.
All right, so I'll hear from both of you in more detail. Mr. Lally, I will hear you.
Your Honor, the jury received this case just earlier this week. They've had slightly shortened days, and I'm not in any way, shape, or form suggesting that they haven't conducted their due diligence in regard to their deliberative process, but I would submit that it is far, far, far too early in their deliberative process to even consider giving them any kind of Tui Rodriguez instruction or anything close to that. Furthermore, what the note doesn't really indicate affirmatively that they can't come to a conclusion. It just says that they haven't come to a conclusion through their deliberative process at this time. They're not even asking for one, is what I would say.
All right, thank you.
So Lally for the prosecution is saying, look, it was a really long trial and it's only been 4 days, not even 4 days. At this point, it was in the morning, this morning, or about noon, somewhere in there. So it had been maybe a total of 3 days that they have been deliberating. And he said, look, they didn't come back and say, we're not going to keep trying and we shouldn't give up now. Don't give up, Judge. And the defense said, let's move to that dynamite charge. Let's go ahead and do that.
Giannetti, I'll hear you.
Your Honor, I would disagree with Mr. Lally's characterization of the note. The word exhaustive is the word.
At least exhausted.
Here. They're communicating to the court that they've exhausted all manner of compromise, all manner of persuasion,
Jim.
and they're at an impasse. This is a case where the jury has the legal instructions. Mm-hmm. They've only really asked one question, which was to try to get a report that they were not allowed to get. And I think the message has been received that the evidence is closed. They won't get anything more. They've been working essentially nonstop over the last 3-4 days. We're approaching a weekend. They didn't come back with this at 3 o'clock or 4 o'clock. They're at 12 o'clock and they have nowhere to turn. So our position is the jury should be read the Tui Rodriguez model instruction and go from there.
Okay.
So he seems to be saying, let's go ahead and get this over with. Let's go ahead and read that instruction and see what happens. Here's what the judge did with that.
All right, so you all know that it is within my discretion, I decide. So a case that has been, it's a long case. This is our 4th day of deliberations, but Tuesday was a short afternoon, maybe 2.5 hours. Wednesday, they left early because of an appointment. Yesterday was also shortened a little bit, and this note arrived with less than 3 hours of deliberations today. So the length of the trial, the length of the deliberations, I know the case we heard from 74 witnesses. There are 657 exhibits, very complex issues in this case. I'm not prepared to find that there have been due and thorough deliberations at this point. So I am going to send them back out. We'll bring them in and we'll do that now.
So the judge is saying, I don't think this is enough yet. And remember how the judge, it said specifically, the judge should make that finding on the record. If the judge is saying this doesn't count as a due and thorough deliberation, then put that on the record so everybody knows that. And that's what she's doing here. She's following those steps and she's saying, I don't think we've hit the point of due and thorough deliberation. So she's saving, or she's keeping her powder dry, as you would say. She's not using up her chance to give that dynamite charge.
All right, so jurors, I'm in receipt of your note. I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict signed by your foreperson. We all know how hard you've been working. Lunch will be arriving shortly. When it comes, I'd ask you to clear your heads, have lunch, and begin your deliberations again. Or continue your deliberations, all right? So I'm sending you back out.
Okay. Can you imagine how the jury felt when she said that? They come back in and they're like, look, we just really can't agree. We've been going at this really hard for days here. We don't agree. We've looked at all the evidence and we just don't agree. And she just says, tell you what, lunch is coming. Let's get back to work, shall we? We are not giving up. Let's just get back to work. And that's exactly what she's supposed to do. But you can just sort of imagine the sinking feeling that all those jurors had, because for many of them, they probably didn't know about this process and they were thinking, that's it. We really tried our best and we didn't reach agreement. How common is this? Well, the Court Statistics Project says that hung juries are just 6.2% of all juries. So it's not really common. But when it happens, it's a big problem. It's a significant one. It's expensive to try cases. It's expensive in terms not just of cost, but also of the time when you think about what the court has to invest in terms of the courthouse, the courtroom, the judge's time, the clerk, the bailiffs, the court reporter. Then you've got the prosecutors and the people in the prosecution office. You've got the defense lawyers, the defendant, the witnesses. It's a massive undertaking. And this one especially, all those witnesses, all those weeks of testimony, weeks of witnesses, and not to mention the jury's time. The jury has spent 8 solid weeks hearing the evidence and trying to get ready to make this decision. So it's a significant problem if a case doesn't get resolved. It's something that is undesirable from pretty much everybody's standpoint. So at this point, it looks like the jury is saying they can't agree. We don't know what will happen when they come back on Monday, and we don't know what will happen if the judge gives them that dynamite Allen Tui Rodriguez charge. We don't know what will happen. But we did see there that the defense was going ahead and pushing, let's just do it. Let's just go ahead and declare this to be the moment when we're going to rush in with the Tui Rodriguez and just get it over with. Now, traditionally, the idea is that a hung jury is good for the defense. And the reason for that is that at least it's not a conviction. Like, the worst possible thing for the defendant is a conviction. So a hung jury is a bit above that. But it's not great. It's still something that has problems because the prosecution can try it again. One of the things the defendant hopes for is that the prosecution will decide, we're not going to try that again. That's too controversial. Obviously, we weren't able to convince 12 people beyond a reasonable doubt. It would cost a lot in terms of time, effort, expenses, money. It would cost all of those things if we went forward. So we're just not going to do that. We're not going to do it again. And that's what the defendant is hoping for, is that ultimately that would be what the case would decide. But I said, I thought, in my view, this case is different. And the reason I think that is because Karen Reed's team did so well. They tried a beautiful case. I think this is as close to winning as they're ever going to get. And the prosecution had some serious missteps. Next time around, they will be better prepared. There's a lot the prosecution cannot fix. For example, Brian Higgins threw out his SIM card and his phone, and you just can't get around that. It's still going to be a fact next time around. The police didn't document the taillight pieces for a year. Still going to be the case next time around. But the witnesses are going to be better prepared. They're going to know what to expect. The one exception I said is that wild card, the federal investigation. And it's hard to know what will come out of that. Will it be something dramatic that will really help Karen Reed? Or will it be not a lot? It kind of fizzles out and nobody ultimately is charged. That's sort of the wild card that gets thrown in there. But my overall feeling is they want this case to be the one that gets decided because they did such a good job. So that's my sort of thinking. So why then is the defense pushing to let's go ahead and get that Tui Rodriguez charge? Well, remember, they're not pushing for a hung jury. They're pushing for that charge. So what they may be thinking is that the jurors are leaning their way. Maybe they think we're the ones who have 10 people on our side and 2 people against us. And it doesn't have to be that they have some secret insight into the jury room. It could be that when they walk back in the courtroom, they feel like the people they expected to be the most pro Karen Reed are looking confident or looking at her. It's little things that lawyers like to read in. And it could be that they're feeling the opposite way about the jurors that they were most worried about. So maybe they're thinking they're in a good position here. And it could be that they think also that the longer the jurors deliberate, then the greater the risk that the not guilty crowd will give up. Even if they're in the minority, maybe they feel like they may be in the minority, but they're really strongly in favor of Karen Reed, but they may not be able to hold out. If they're in the minority, maybe they'll just give up and here's the nightmare, agree to a lesser included offense. And that would create a huge problem. So they also may think that the chances are strong that if they can either win or get a hung jury, well, if they win, the prosecution has to give up. But if they get a hung jury, they may feel like, given how controversial this has been in the community, that they have a really good shot of getting the prosecution to drop the case and to decide it's just not worth it. It's not worth it from the expense or the community standpoint. But on the other hand, and I saw a couple of questions like this, yes, Karen Reed would have to pay her attorneys again, and they would have to pay their experts if they paid their experts at all. They were not paying the 2 who came from ARCA, but if they are to pay those experts, Karen will have to do it out of her pocket. It depends on the lawyer's agreement. Maybe they don't get paid for a second trial, but normally I would expect if the first trial results in a hung jury that they would get paid a second time. It wouldn't require as much work, obviously, as the first time, but it still would be significant. So then the question is, what comes next? What is going to happen next? So sending them back the first time, just saying, no, let's keep going, that wasn't enough. So I would expect on Monday, if they come back fresh on Monday and they aren't in agreement, if a comment comes out like the jury made last time saying, we're really at an impasse. I believe she will give the charge and we'll see what happens. We'll see whether there is some agreement. Now, I wanted to show you that this is pretty controversial and talk to you about why. Let me add to the screen. Okay, so, and I am going to actually show you, put your lawyer caps on, because we are actually going to look at a law review article. Don't worry, we only have like 3 sentences we're going to do from it. You don't have to graduate from law school. I'm just going to show you some things that it said just to give you an idea of why that dynamite charge is controversial, because I think it ought to be. And one thing it said in here, that the solution back in the 14th century was that if the jurors couldn't reach an agreement, they would be loaded onto ox carts and carried around with the judge until a verdict was reached. So these jurors, at least it's not that bad anymore. So I thought that was pretty funny. I also thought interesting, the original case that the Allen charge came from was a Massachusetts case, but now they call it Tui Rodriguez, so go figure. Okay, so one of the concerns is that it will reinforce the view of the majority, since the charge contains no admonition that majority jurors should re-examine their opinions. It doesn't say really either way. It just says, if you look around you and other people don't agree, rethink. And it says the charge usually comes at a psychological low point in the proceedings, when suggestions calculated to bring agreement are apt to be met with less than ordinary critical evaluation. So in other words, the jury's going to be kind of vulnerable. If you come in and say, look around you. I mean, if nobody else is agreeing with you, ask yourself if you're right. And everybody's just beaten down and exhausted, maybe that's the very moment when they give in. While the purpose of the Allen charge is to, and this is where I think it really gets strong, where the purpose of the Allen charge is to eliminate, where possible, mistrials brought about by hung juries, this is a legitimate purpose only if the change in minority opinion is accompanied by an honest change in its view of the evidence. I'll break this down in just a second. A change induced by pressure, no matter how subtle, is an unwarranted infringement on the function of the jury. If unanimity is to have any real meaning in criminal jury trials, each juror must be convinced by the evidence presented of the accused's guilt beyond a reasonable doubt. That is the part that I think is super important, because if the entire point of having a unanimous jury is that everybody is supposed to have their own thoughts, and if even one person disagrees that all of the elements of this charge have been met, then there's no conviction. That's what it means to have a jury that's unanimous. And the law requires that. The Constitution requires that, I assume in Massachusetts, requires a unanimous jury. And if what you do is come in and say, hey, look around you, if you're the odd man out, then maybe it's your problem, then you've undermined that. You might as well just say we don't have a jury system that's unanimous. You might as well say it's a majority vote if you put pressure on somebody. So that's why it's controversial. So I would be very interested. Go ahead and put in the chat what your thought is. Do you think there will be a verdict? Put 1 if you think there will be a verdict for the prosecution. Put 2 if you think there will be a verdict for the defense. And put 3 if you think there will be a hung jury. So go ahead, and I'm going to head over, and I haven't gone to any of my comments over here yet, but y'all go ahead and be putting that in, and then I'll go back and read that. So Maya is a new member, and we are delighted to have you. Oh, thank you, Mandy. She was asking how to gift memberships, but I appreciate the super chat very much. Thank you. Andrew, here in the UK, a judge can accept a majority verdict. So that shouldn't be the way it is here, Andrew, but the complaint about that dynamite Allen charge is that it may kind of force the jury into that very position. They do it on their own. It's not the judge literally accepting the majority verdict, but it is a situation where the judge's pressure may have created the verdict that was a majority verdict and made it into, quote, unanimous. So that's sort of the issue. Thank you. Wonderful. I appreciate that very much. And I'm so sorry that you're a widower as well. A new member, the purple. That's great. Oh, and Mama Pinks is giving directions on how to receive gift memberships. So if we have some people who bought memberships to distribute to other people, memberships to the channel, you can watch any of our videos for free all the time. Memberships are just a way to get to financially support the channel, and we do some extra activities. One great thing is we have these amazing emojis that you can use during the chat that our own moderator, Marlon, has made. Mama Pinks is our other moderator, and we are very grateful to both of them on the channel, let me assure you. Okay, yes, good point. To become a member, Mama Pinks is pointing out, iPhone users need to go directly to the website because usually on your phone, there's not a join button. I'm struggling over that. I'm working with YouTube on that. I'm requesting that. But for some reason, while some channels get the join button, we are not in that lucky few yet. So I'm still working on why not. Yes, neuropsych is correct that at 3:45, actually, I think at 3:30, the judge said she sent in her usual note at 3:30 saying, you want to leave at 4? And they wrote back, we want to work till 4:15. And then they did, and then they left. So a lot of people thought, oh, that's great. That means they're filling out the verdict form and we're going to have a verdict by 4:15. But that isn't the way it worked out. It turned out to just be, I don't know, maybe they were reviewing something and they figured it would take them a little longer, a little past 4. But that's kind of the way it went. And thank you, Dr. Sauce, for the super sticker. I appreciate that. So I'm headed over to see what threes, ooh, lots of threes, 2s, 3s, 2s, 3, et cetera, et cetera. So I would say I'll put an actual poll on the community page. So if you go to my channel, underneath it, it shows video, live, et cetera. And one section is community. So I'll put a poll under there so we can get an official count. But I'd say y'all are looking pretty hard at hung jury, which is interesting because when we did that vote a couple of days ago, right when the jury first went out, it was heavily that people believed there would be a verdict for Karen Read, a not guilty verdict, and then split among the other, I think it was 70%, and then split among the other things, but it was not heavily on it being a hung jury. But I think a lot of people are switching over now. It's been 4 days, right? So clear 21 hours is a lot of time, and they are saying they can't resolve it. So we will see how strong everybody is at the end of that. Okay, so go ahead and put your questions in the chat if you would. If you would put question marks at the beginning, it makes it so much easier for me to find it. So I will be looking through for people with questions. Lots of 3s. That's kind of what I'm leaning toward too, but we will see what that dynamite charge does. If it's a really lopsided group with 11 people who are in favor of one side or the other and one holdout, I think that's when the dynamite charge is most effective. But if it's more than one, and in a case like this, I mean, just look at what's happened in the community there. Now people have been charged with assault and battery of Turtle Boy, who has been supporting Karen Read, and they've been charged of assault and battery from an incident that happened last weekend, just on the streets, just fighting over what's happening inside the courtroom there. So it is wildly controversial. Okay, so I'm headed over to look for question marks. I hope I didn't go. Okay, here we go. I think I'm about it. Your True Crime Library is asking, did George ever get any funny reactions? That's my husband who passed away last month, when he told people his name was George Wallace. Well, I'll tell you, the funniest reaction was when he told me that his name was George Wallace when we first met, and I didn't believe him. I thought that couldn't be. Another fun fact, when he was paralyzed, somebody told George Wallace, former governor of Alabama, who also was paralyzed, and he wrote George a letter saying, he was sorry to hear what had happened, and he knew that this was hard, but, he wished George well and that he could still go on and have all of his life ahead of him. So it was that was an odd connection between the two different names. But yes, that was I didn't believe him when he first said that. I didn't say anything. I just decided to go with it. I'm like, well, maybe it's for real, but it seems so improbable. Okay, and let's see what Arnett misconstrued. How would we know a cop on the jury, or is it just rumor or gossip? I've heard people talking about that, and there is information out there. When they answered their jury questionnaires, there would have been people in the courtroom and talking about that during voir dire. So there could well have been people who know that someone on the jury is a cop. There's nothing inherently wrong with having a cop on the jury. What happens with a jury selection is everybody comes in, they're in a jury pool. Some people will be struck by the judge because they just aren't eligible to be jurors for whatever reason. But other people might not be desirable for one side or the other, but they aren't ineligible. And so the judge doesn't strike them. And then each side only gets some number of strikes, 3, 6, some number. And they can eliminate jurors for no reason other than an improper reason. They can't do that. It can't be based on race or gender. So, but they can eliminate jurors just because they think they wouldn't be good. But a lot of times, let me rephrase that. Every single time you run out of strikes, there are always more people you would love to strike that you can't. So that would be how they would know. I can't say for sure whether that's true or not. Annie K wants to know, what do you think is the obstacle to complex a trial? You know, that isn't what I think, Annie. I think the obstacle is that people disagree on this case. I think that if you go in any of the live chats on where people are watching the trial as it's going all day long, you just see wildly different views. You see a lot of people who are saying Karen is guilty, guilty, guilty. And you see people saying, Karen has been framed. And they see the evidence, same evidence, and they see it differently. And I think that's going to present a problem. I saw a comment on X by Turtle Boy saying that there is no problem with the hung jury because there's no possibility that the state is ever going to find 12 people to convict Karen Reed. But I would say the opposite is probably also true, that the Karen Reed's team is never going to find 12 people who will say that she is not guilty. It seems to be divided. It seems that some people believe she's guilty and some don't. And that difference of opinion is playing out in the jury, just as it's playing out in the live chat, just as it's playing out on the streets in Canton, just as it's playing out across the world as people watch this trial. Jamie asking, do you believe that they will find her not guilty on the top charge and then hang on the lesser? Jamie's asking a good question because we don't know what they're differing about. It could be that they decided not second-degree murder, and they're all the way down to one of the two included lesser offenses. But we don't know. We don't know where they stand in that. It could be they're close, or it could be that they're very much not. So, all right. Angela asking me, can they poll the jury? No. And one of the things that the judge, and I read some case law on this today, but it's very questionable for the judge to say, okay, so you're split. Where are you on that? And the reason that it's bad is because the judge is then going to give them something saying, pay attention, look around you, see what other people are thinking. And don't be so stuck on yourself that you think your opinion is the only right one. If the judge knows where they stand, maybe that's a little questionable. So it's advisable for the judge not to ask that and not to know where they stand. Lisa wanting to know, could a judge be named in an investigation with co-defendants? So I guess I think, Lisa, that what you're asking me is whether or not there could be a judge who oversees an investigation into some of the witnesses here who perhaps said things that were false or who are not believed. And that's something that a judge would preside over. There could be an investigation. In fact, we know there is one federally. We know that the feds are looking at this and specifically looking at Trooper Proctor. We also know that there's been an investigation by the state police into Trooper Proctor. So we know that there are investigations going on, probably not straight up with a judge, but people are looking at this. Okay, Amanda asking, do you think a retired police officer causes conflict to serve on the jury? Not necessarily. Obviously, that would be one of the people that the defense would want to strike. The defense would have every reason to be worried about that. But maybe they just did not have enough. There was someone else even worse, because that's what striking a jury is all about. When you use up those strikes, you're looking for the worst possible person for your client, the one you really think cannot be fair to your client. And inevitably, you think that's true of more than you have strikes. You're thinking all of these 8 people, but I only have 3 strikes, and you just got to figure out in there where it is that you think, which ones are the worst, which ones are the ones you just really have to get out of there. So that's what you're going to be looking at. S. Cipher, is it true the jury foreman is a retired cop? Ooh, now I'll tell you, isn't that a conflict of interest? I don't know that. I cannot answer that. But remember that the judge appointed the foreman or foreperson. And if that is a retired cop, that would be something that would be of grave concern to, would it be improper or wrong? I guess not. If that's something they normally do is appoint the jury foreperson, then I don't think there's anything specific that there's a problem with. But that would mean that the judge picked out a potentially very pro-Commonwealth juror to be in charge, to be the person who would be in charge. And I don't know if it's even a man or a woman. I don't even know that much. Although I did think it was a man. Okay, Janice, thank you. And Janice has a question. If jury agrees not guilty on everything, but hung on the least charge, can they prosecute again on all charges or only the one they're hung up on? So if they get a not guilty, they could start the case over. I mean, they can start the case over and say, okay, we're going to declare that we're going to start this whole case over. It was a hung jury and we're going to try this again. I don't think that they're shut out of those charges. That's an interesting question. I'm not totally sure about that answer, Janice. So that's what I think, but I'm giving you my off-the-cuff reaction. So that's worth looking at. I'll see if I can find out. Okay, Mob wants to know, why can't we know what the votes were, how many for and against guilt? And that's because the jury is sacrosanct. We aren't allowed to go inside and find out what they're doing or how they voted. It's considered private, even more so than your vote, although obviously that's very private too. So we aren't allowed to do that. At some point, it no doubt will come out. That'll be after the trial, and it'll be because jurors talk about it and nobody has to reveal how they voted. Ducati Girl asking, I've seen cases where the judge doesn't accept the jury decision and rules the other way. So what can happen is, in this case, let's say the jury found her guilty. The judge could say, well, I've looked at the evidence and I believe that would be an improper decision and would state the reasons. That so rarely happens. That's exactly what happened. Remember that motion that happened in between when the prosecution gave its case and the defense gave its case. There was an argument right in the middle of that. And I said, lawyers always do this and they always lose. So that's something that happens. But there can be, the judge could reach some kind of verdict notwithstanding what the jury did. But if the jury acquits her, the judge cannot just undo that unless there's something very improper or unusual that doesn't get undone. Once the jury acquits her, that's that. Locutus is asking me, if hung jury, can the prosecution let go of some of the charges before the next trial? Yes, they can, and they would be very well advised to do that. They should, but they may. One of the reasons that second-degree murder charge is in there almost surely is because of the fact that second-degree murder charge was their ticket to get in some evidence, that would maybe show the jury that Karen Reed had a motive, that she wasn't pure as the driven snow. That would be the things like her fight with John O'Keefe. If all this is involuntary manslaughter, intent is irrelevant, then her side is going to say none of that comes in. Who cares why she's texting him? We don't care about her intent. So all of that is out. And so one of the reasons that that extra charge was added was for the purpose of getting that evidence in. Okay, if Karen is convicted, this is Lisa, and later the FBI finds there was corruption in the investigation, theoretically what happens? Well, theoretically, she would bring that up most likely on appeal, depending on kind of where the case was. And she would say, the FBI has found this, and we believe these findings undermine the guilty verdict against me, assuming there is one. And then it would go back. The appellate court would decide, is this enough to undermine the fairness of her trial? Is this enough that that we think this should have been presented at trial and would have potentially impacted it? And that's the basic decision they would be making. Okay. Hold Yaman is, if this was your case, would you select the judge instead of the jury to decide the case? Thanks for covering. So I would say in this particular case, I would not. And primarily because this particular judge has, I think, overall been not favorable to the defense. So I think it would be very risky to have this judge. Even more important, though, for most defendants, that's going to be the case, because for most defendants, what's going to, for almost all of them, they want those 12 jurors, because then if they have one holdout, if they can get one person to say not guilty and that person withstands that dynamite charge, then they're not convicted. So they have 12 shots at it, 12 shots at finding the one person who will say, I find not guilty. And for that reason, it would be unusual. And thank you, Margie. I appreciate it. Okay, we'll do a couple more questions and then that'll be it. Canton Capoodler wants to know, is it possible that the state can say that they do not want to go to another trial and dismiss the charges? Yes, that is entirely possible. The state has the authority to do that. And one of the things Karen's team has got to be hoping for is that they will actually do that, that they will make, that they are going to decide that they are stopping right there and they're not going to go through this again. It was too much. It was too expensive. It was too controversial, and they don't think they can win again because they don't think they are ever going to persuade the jury. And that would especially be true if it's very lopsided in favor of Karen Reed. If there are 10 jurors for Karen Reed and 2 for the Commonwealth, then the Commonwealth has to think long and hard about whether or not they want to go forward, because it looks like it, especially if they don't have anything more to offer next time. And even worse, if the federal investigation has actually moved forward and there have been charges brought against anybody. For all of those reasons, they might reconsider that. Okay, let's see. Looking for, Susan asking me, if a hung jury, would the jurors be allowed to talk to journalists after the trial ends? Yes, they would. There's nothing preventing them from doing that, but they would have to make that choice themselves. They won't be told to do that or anything like that. They'll be told it's your choice. You get to decide whether you want to talk to the media or not. And I assure you, the lawyers will be wanting to talk to them too, because the lawyers are going to be trying to make choices and decisions based on what they say. If it's a hung jury, that becomes especially important, because what didn't persuade them? What was persuasive? What were they looking at? So Janet is saying that her second grandson arrived this afternoon. That's wonderful. Congratulations. And she's grateful for his safe and quick birth. Obviously a wonderful thing. Well, I do want to leave y'all with some AI summary jokes, because y'all sent me some awesome stuff this week. And I wanted to show you some of the really good ones I got. These are where if you refresh periodically, somehow YouTube has added an AI summary of what the live chat is talking about. And sometimes it is hilariously off. It just, These things, like what? They don't know who the defense is. They don't know who the plaintiff is. Or the prosecution. They just are plain confused. So anyway, I thought some of these were really pretty funny. So let me add a few in there. And let's see. Oh, wait, that was about moral certainty. Okay. So this is from Becca. People are discussing the casting choices for a potential movie adaptation of the Koberger trial. Oh, I'm not showing it on the screen. Let me add it to the stage. With suggestions ranging from Jim Carrey as Jen McCabe. Wow, that'd be wild. To Bette Midler as Beth. The ongoing trial, which has garnered a lot of attention, is still deliberating on the verdict, while some viewers express frustration with the length of the deliberations. Certainly true. The next one came from Nancy. This live chat is about the ongoing jury deliberations in the defamation trial between Kimberly Guilfoyle and Steve Bannon. Like, what? Where did that come from? And so viewers are discussing the case. Then I can't read the name. Let me see if I can make this bigger because I want to give credit where credit is due. Oh, darn it. I can't read the name. The ongoing chat covers the ceiling fan being on for a long time, which everybody is talking about the fan. A hung jury in the Amber Heard Johnny Depp defamation trial. Chat, pull up. What are you talking about? And a general dissatisfaction with the court proceedings, which I certainly think would be the case. And this one, the ongoing discussion is around a court trial where Bev, a judge, is accused of being biased towards the CW, which stands for Commonwealth, but which AI interpreted as child welfare. Her nephew, Alan Jackson, might be having an affair with Karen. Her nephew. The police are allegedly driving under the influence during work hours. That was actually something seriously discussed because they were all talking about how much they were drinking. And then Brian Higgins, after having these drinks, went back to the police station to move cars. And viewers believe justice was not served. Definitely something that was talking about. So please continue to send me those because I'm just getting a serious kick out of that. Also, if you see really good fan jokes, I think those are really funny. Like about the fan, there are just some really funny ones about that white fan that we're all watching go around and around and around. So thanks for watching. We will be live again on Monday night at 7 p.m. We will be finding out what the jury says, and I will look forward to seeing you then.